Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend, Russ Cook, with Russ Cook & Associates over in Brentwood, Tennessee. Russ and I have been working together with clients for, gosh, I think 15-plus years now.
Very, very long.
Yeah. So, I mean, and I'll tell you, I trust Russ, and and his documents are some of the best you're going to find. I've been through with clients where because of that long time, and because, as I talked about earlier, people tend to procrastinate, or we're making changes later in life to documents. So I've seen not only Russ's work up front with clients as we work together in setting up plans and that, and he does great documents, but also saw the strength of those documents when they've been tested at times, when we've run into after someone has passed away, and we actually then get into the administration. So again, can't speak highly enough, and you're going to get an opportunity again for the first 10 callers to my office, not to the show, to my office, 615-376-5325. Debbie's there to take your information. She'll send you out a checklist of things to bring to your appointment with me. We're going to do up a full plan for you, okay, at no charge. And with that, if you want to get an estate plan review, we can meet first, then bring Russ in, or we can set it up to where we can have Russ there at the meeting. If you want to specifically get right into the estate planning part, if that's your biggest concern, we can handle that for you. And I'll send you a copy of my book, 7 Steps to Financial Freedom in Retirement, for those first 10 callers. So there you go, 615-376-5325. All right.
Yeah, and call Hank's office, because if you call my office, you'll get a charge. So make sure you call his office, and we'll setting you up for a no-charge deal. That's it.
So free consultation if you call me. Russ will come and do that. But if you call Russ's office, he normally charges for that consultation. So here's the other part of this. One of the things I want to understand is Russ is one of the best out there. He's a board-certified estate planning attorney, one of the few, in fact, in Tennessee. And here's something else in 30-plus years experience doing nothing but estate planning, and that's the other part. You know, if you go to an attorney and they're doing half a dozen, or they do everything, and you say, "Oh, I need a trust," and they're like, "Well, let me look that up." You know, they're used to most every attorney will do a basic will for you. But then again, sitting down with someone and talking through your situation and seeing if that's the best in your best interest to have a will. So let's talk about, in fact, what happens. Because there's a lot of misconceptions. People think, well, I've got a will, therefore I don't have to worry about probate, or maybe even what is probate. All right, so let's talk about that. So you have clients that sometimes a will is the appropriate thing, and now someone's passed away, the family comes to you with the will. Let's walk through that process of what needs to happen with regard to probate.
Well, the first thing we have to do is gather the information to go ahead and prepare a petition to file with the court. The petition to probate the will usually requires us to obtain all the family information, not only the people that are listed in the will as beneficiaries, but also the heirs at law of the decedent. So in the case where someone's, say, writing out a child, disinheriting them, we still have to report what that disinherited child's name and address will be, and we have to send a copy of the pleadings, depending on the county, to that child. So there's the first hiccup. The second one is once we obtain all the information, we sometimes, depending on the county again, have to put into the petition the value of the estate. And that's another piece of information that people don't normally want to see made public record. Once we get that prepared, then we go down to the courthouse, and depending on the county, it's either in front of the clerk and master or the judge. And then we ask the judge or the clerk and master to accept the will for probate, and they appoint the person named in the will as executor to be executor of the will. And there's a notice published at the local paper telling everyone that this person is now the executor of the estate, and if they have a claim against the estate, they have a period of time in which to bring it.
How long do they usually have that's open for? So basically, this is a public notice. Anyone now that has a claim at all, or thinks they do,
Yes.
This is like a public forum. You can come forward. It's very easy to make this claim as far as the court will accept this stuff and at least look at it. It's got to be valid, hopefully, right? But how long does that notice put in the paper? How does that, there's a time limit, right?
Well, the time limit to keep the estate open is 4 months, usually from the first published notice. And usually they publish the notice for 3 consecutive weeks. And it does offer the opportunity for people who think the decedent owed them money to file a claim. And in a lot of cases, we get claims that are fairly frivolous, which means that we have to deal with them in some way or another, because the court won't let us close the estate until we deal with the claim. And so that means there may be some added expense handling that.
And this is where, like, if there's dispute in a family about assets, this is one of those that can drag that probate process, which, so would you say that probate normally about 9 to 12 months, right?
9 to 12 months. Usually you want to wrap it up in a year, because most counties will ask you for a status report if you have not wrapped it up in a year. They anticipate that it'll be done. And since we don't have a Tennessee inheritance tax, we're not required to file an inheritance tax return, so that allows us to speed up the process.
Unless if there's a dispute, that's what can sometimes drag that on, and the longer it goes, of course, the more expensive, right?
Yes. And normally when I hear about horror probate stories, it's because there's a dispute. It's because the executor appointed is really not doing their job. They're dragging their feet, or there are hard assets to deal with, like businesses where people really didn't do different, didn't really plan out how that's to transition. That's going to be much harder,
especially if you've got if you've got a business. Think about that. This is one of those. It's great point Russ is making. If you own a business and if you don't have a succession plan, okay, is the family going to be the one taking over that business? Are they qualified to do so? I mean, in some instances, the families work together in business. It's not unusual for for husband and wife, for instance, to work together in a business, nor for that matter for children as they get older to maybe join a business. But if that's not the case, what's the plan in place? Who is going to take it over? Is it going to be sold? And can it be sold? And how easily and how long might that take? And how do you arrive at values? I mean, it gets really difficult in that situation. If you've got partners and then the partners are dealing with the family, all of that's got to be much more difficult.
Yes, it is. And that's probably one of the bigger holdups that we have in administering an estate. And unfortunately, a lot of people don't really give it as much time as they should. A lot of times we find that the parents just think that the kids are going to share it equally, and that's not necessarily the best plan, because some kids might be in the business, some kids aren't, and it really lends itself to a situation that gets very complicated very quickly.
Now, here's one of the things to understand too when it comes to the courts. What's happening? You're going into probate because you've got assets. Your will is saying this is who I want those assets to go to, but those assets are still titled, okay, in your name, as an example. Now, for a husband and wife, this can be a little different, and we're going to talk about that part a little bit as well. But understand, this goes to the beneficiary designations. If you've got beneficiary designations filled out on your retirement accounts, very, very important, that's going to pass before probate, okay? So that'll go direct to the people that you've left it to, and there are so many reasons that's important to have that done right. There are different rules that the company plans can have that can restrict how those monies are paid out. In some instances, might require a retirement account, for instance, if you've not named a proper beneficiary, to have to be paid out over a 5-year period to the estate. Now all of a sudden you've got you've created a much bigger tax problem, because that account, if it has to be paid out in 5 years, could be a lot more taxes, higher tax brackets and the like for the beneficiary. So there's a lot of problems that come in with not having that part done. If you've got that done, that's going out ahead of probate, but now you've still got real estate and other accounts that maybe are in joint ownership or the like, or if they're, not in joint ownership, but in your name. So for a single person or for someone that with a house, spouse. How do you, and that's the other, yes, if it's a surviving spouse, single person, when the house and the property is going to the children, it's in their name, that's one of the functions of probate court, right?
Yeah, its job is to make sure that clear title is transferred to the kids. And depending on the nature of the property, sometimes you can go through an abbreviated probate if that's the only asset that you're dealing with, or in most cases, if you want to make sure you're not running into a title issue, we might go through a regular probate. And one other thing that people have to bear in mind, whenever someone passes away, you always want to get a release from TennCare.
Right.
You know, it doesn't matter if they were on TennCare or not. TennCare has an automatic lien against assets when a decedent passes. And if you're opening probate, they won't let you close it without getting a release from TennCare.
And that's one of the advantages. So, and now you can do this both with, we're going to talk about how this feeds into a trust as well. But on that will, as Russ said, with a TennCare release, think in terms of you can't sell your house, okay? If it was even in joint ownership and that first one passed, without that release, then getting clear title is going to be a problem, and you may have to go back and redo things if it weren't done. And this is one of those areas where sometimes when the first spouse passes, there may not be a need for probate. Everything might be joint ownership, beneficiary designations, and so there's no need, but you still need to get those TennCare releases.
Yeah, you do. And there's a reason that you might want to reconsider, because I think you're teeing up, well, how can I get out of this probate deal? And a lot of folks think, well, we'll just make everything joint, beneficiary designations. And yeah, in some cases that's fine, but in other cases, what it does is it offer us a level of protection that we can get. It doesn't give us some income tax benefits, and if you put a kid on your account, then it exposes it to the child's creditors. So
joint ownership definitely has its pitfalls. We've got a caller. I'm going to try to get in before the break. This is Bob. Bob, welcome to the Retirement Report.
Yes, I had a passed away, and the big issue was she lives in Florida and I live in Tennessee.
Right.
And I was down there in Florida, and I run up on a couple of things that didn't get mentioned in the when they sold the estate. Like for instance, she had $75,000 in bonds, and what had happened, my aunt, I had an aunt, and what she does, she took the bonds, and then never was reported on the estate. But there was a lot of other stuff, because what had happened, didn't nobody go in there and write everything down that was there, and they just started taking stuff and giving stuff away that was in the house.
Personal property and stuff, yep. Yeah, this is one of the common things. There's a couple of things there, too, that go, in addition, when you get into other states, and we're going to talk, when we transition over into the trust after the break, I'm going to get into more with Russ about how the trust would work compared to the wills. And this is one of the other areas. If you get into other states, we're talking about Tennessee law. The laws are going to differ per state. And they can have different, how that probate's going to work, the intestate laws if there's not a will, how things get divvied up, if you will. If you've got property in multiple states, what kind of impact that can have. Now, in those bonds, I don't know if they were on joint ownership, and that's how, and it could have been that she had, one aunt left, sister to sister, it sounded like. Did I get that right?
Yeah, she was sisters, and one of the sisters just started taking over.
Yeah.
See, my thing is, when somebody passes away, somebody needs to go in there right then, take pictures and write everything down, because I've had this happen twice with two different family members. They just went in there and just started taking stuff.
People just kind of, kind of like the Hobbit. Everything just started disappearing, right? Yeah, I hear you. I know, and I've had that happen with clients in the past where, at a wake, all of a sudden people are putting things in their purses, and it's kind of shocking at times. This is, it is important that things in the way you handle when it comes to the administration of the estate as well. So we're going to take a break. Thanks, Bob, for your call. When we come back, we're going to get into a little more about how you can protect yourself with with these things. And just as Bob was talking about, there are ways in the administration of a state that you can protect the family and make sure that things get handled appropriately and proper and with decorum, so you can minimize these kind of things from happening. So again, when we come back, we're going to get into trust a little bit. Now that we've talked about how wills work, we're going to talk about trust and some of the benefits they can provide that you may find that this would be a better route for you. All right, so join us. We'll be right back on the Retirement Report.
This week